Welcome to the next episode of Called to the Bar, International Law Over Drinks, a series of casual conversations about current issues in international law, life in academia, and whatever else is on our mind. Remember, in these conversations, we are speaking off the cuff and without benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Dr. Juliette McIntyre, Senior Lecturer in Law at Adelaide University, and today we will be talking all things evidence at international courts and tribunals. What's a sketch map? What does the court do with all those annexes? Why aren't there any rules? The answer to these questions and more will be answered by my guests today, James Devaney and Cecily Rose. James is a professor of international law at the University of Glasgow and the author of what is basically the book on evidence, Fact-Finding Before the International Court of Justice. I have read it cover to cover more than once. Cecily is an associate professor of public international law in the Grotius Centre for International Legal Studies, a member of the Dutch Advisory Committee on Public International Law, and an arbitrator with the Award Review and Debarment Board of the NATO Support and Procurement Agency. So Cecily can give us an insider's view from the bench of some rules of evidence. Welcome both to the pod. And of course, we must begin with our first question. What's your drink?
I'm drinking just a cup of tea. Not very exciting.
Very civilized for what time of the morning it is where you are, I think.
Yeah.
Yeah, I'm afraid I'm much the same. Since it's before midday, it's just a coffee for me.
See, I've gone for a Tancello liqueur, given that it's very late at night for me and I'm finishing off from dinner time. Now, look, you are both first-time guests of the podcast, and so I would love to get a little bit of biography from both of you for our listeners. Can you tell us a little bit about what was your pathway to your current position? Now, Cecily, you and I know each other from Cambridge many, many moons ago. So would you like to start us off?
Sure. So I've officially now been in Leiden working at the university here for 12 and a half years. So time has flown by. And then before that, indeed, I moved around a lot. So before that, I was working at the ICJ in The Hague. And then before that, of course, I was in Cambridge doing an LLM and a PhD there. And then, yeah, before that, in private practice and also as a trainee at the ICJ and at the Special Court for Sierra Leone. So my travels have come to my continual moving has really come to an end over the last decade.
You're another one of these refugees from private practice that we sometimes have on the pod. James, what's your story?
Well, I'm from a once great shipbuilding town just outside Glasgow called Clydebank. I studied law in Glasgow, both at undergraduate and master's level, where I was lucky to be taught international law by some fantastic teachers, Teresa Donnell at undergraduate level, and then people like Christian Tams, Adonis Anakopoulos, and Akbar Razalov, some of whom are now current colleagues or became colleagues in later years. After that, I went off to Florence to the EY to do my PhD, which was on the topic of fact-finding before the ICJ, some of which we'll discuss today. And at that point, once I finished the PhD, I said I didn't want to come back to the UK or to be an academic, but somehow I've ended up being an academic in the UK now for the last 10 years or so. I've been at Glasgow, where I'm now a professor. I've managed to escape Glasgow a few times, most notably to the KFG in Berlin, which became my sort of second academic home. This research group led by Gerb Nolte, Heike Krieger, and Andreas Zimmermann. And yeah, that's where I've carried on work on some of the topics that we're going to discuss today, which I'm very much looking forward to.
Yes, I'm excited. So look, I mean, without further ado, we may as well jump in because I think there's a lot to discuss on this subject matter, evidence. So let's start fairly broad. James, in your book, which was published about 10 years ago now, you describe the International Court of Justice's approach to evidence as reactive. So the court lets the parties control proceedings, and basically there's just not that many rules about what can and cannot be submitted. Would you say that the same thing holds true today, or has the court grown?
So I would say much of what I wrote about the court still holds true today. I think the court is still broadly reactive in the sense that it allows the parties themselves to drive the fact-finding process. It's certainly not the case that the court regularly uses all the fact-finding powers that it has to sort of take the lead in doing fact-finding before the court. But as you said, Juliet, I mean, the book was published 10 years ago now, and there has been actually a lot of practice in relation to fact finding before the court. And I think we have to also acknowledge that, some of what I wrote then is out of date because the court has made some, I think, real sustained efforts to improve how it does fact finding, in particular, since the sort of, I think the turning point for the court was the pulp mills case in many ways. So, in relation to certain issues, there have been clear improvements. So we might touch later on the issue of phantom experts, for example, or the issue of experts appearing as counsel rather than as experts subject to cross-examination. We even have had the court use its fact-finding powers to appoint its own experts on a couple of occasions. So I think we have to say that whilst the general approach of letting the parties drive the fact-finding process remains the same, I think we have to be fair to the court and say that it's certainly made a sustained effort to respond to, I think, what were clearly merited criticisms of how it did fact finding sort of traditionally.
Yeah. And Cecily, I mean, do you obviously have experience with other international courts and tribunals. Would you say that this is like an ICJ exclusive, this reactive approach to fact finding, letting the parties guide proceedings when it comes to facts? Or is this a similar thing that you find in other courts and tribunals?
Yeah, I think the comparative question is a really important one. First, let me begin by saying that I really agree with James's overall assessment that in general, the court does take a fairly reactive and passive approach. Maybe that's somewhat less true today than it was 10 or 15 or 20 years ago. But I think that characterization is still very much in general correct. And I think the comparison with other international courts and tribunals makes it all the more clear. So, I mean, if you look at, because of partly because of the doctoral research that I did on corruption, I looked, for instance, into how investor state arbitral tribunals deal with allegations of corruption, which was actually one of the ways in which I initially became interested in the topic of evidence before international courts and tribunals. And then my time at the ICJ sort of compounded that. But what I think what you see there is that tribunals in that context are much more willing to ask parties to specifically produce particular evidence and to really insist on it. And then you see that they're also willing to draw, in certain circumstances, adverse inferences if the party that's been requested to provide evidence hasn't done so. The tribunals are willing in certain circumstances to then draw a negative factual finding on the basis of a failure to basically cooperate. And then I think another good comparative example is from the recent judgment by the European Court of Human Rights in a case brought by Ukraine and the Netherlands against Russia. So there we have a massive 500-page judgment. And what you find there that I think is interesting from an evidentiary perspective is that the court speaks at length about not only Russia's failure to cooperate in terms of the investigation of the downing of the MH17 flight, but also its failure to produce evidence requested by the court. And there the court does draw adverse inferences. And we just don't see the ICJ doing that. The court doesn't request specific pieces of evidence from the parties. That's not a part of its practice. And we don't see the court drawing adverse inferences. And as James has indicated, they also tend not to appoint experts. If you look comparatively speaking at the practice of the tribunals that are functioning under the auspices of the PCA, I think you see more reliance on tribunal appointed experts there.
Yeah, and do we have any, I'm going off script already, we're only one question in. Do we have any idea of why the ICJ is so different from other courts? Because your description matches with my experience of operating as a litigator at some of these courts that, appearing before an ICSID tribunal is functionally no different from appearing before a domestic court, really. Whereas the ICJ obviously is a special case. And I have heard some argument made that it's to do with the way that the court, that is the ICJ, treats state sovereignty very seriously and wants to be borderline deferential to the states that are appearing before it, partly perhaps because it's concerned about losing business if it's too bossy, because of course this jurisdiction is not compulsory. Do you have either of you have any thoughts on why it is that the ICJ is like this?
Yeah, I mean, I think you alluded to some of the reasons there. There are many more though as well. I think, certain things really militate in favor of the court approaching fact-finding the way that it does. In particular, the fact that you have 15 judges most of the time there, everything has to be, or at least traditionally was coordinated through the president, I think, means that it's kind of difficult to have this interactive approach that you might have before arbitral tribunals where you maybe have three arbitrators, for example. The court's statute and rules as well, I think, dictate that. They're fairly skeletal and they're sort of a weird mix between common law and civil law. And that's also reflected on the bench where you have, of course, representation of the principal legal systems of the world and each judge bringing their own conception of how fact-finding should be carried out with them to the ICJ. So, you would speak to certain judges in the ICJ and they will just say, for example, it's not for the court to do fact-finding. They see themselves as being a sort of court of last resort, like one of the highest courts in maybe in a civil law system, which doesn't do fact-finding, right? So actually convincing judges like that it would be important to maybe appoint an expert or to use certain other of the fact-finding powers that the court has is quite difficult. And there's also the issue that you mentioned there, of course, about the identity of the parties, right? They are sovereign states. The court, I think, will always be sort of deferential to sovereign states, and it will be wary of maybe pushing states or counsel for states to answer on the spot, because there's maybe an idea that the counsel would have to get things cleared with their clients before they respond. So if you compare that to the court asking questions of experts, for example, as we saw recently in Gambia and Myanmar, experts are expected to answer on the spot, whereas questions are put to parties and also later in writing. They have time to go away and think about it, come back and integrate their answers into the second round of oral proceedings, for example. So I would say there's a number of reasons why we have sort of ended up where we are today in relation to fact-finding before the ICJ in particular.
Yeah, I'd like to pick up on a few of those points. I think I agree with everything that you said. And I think one of the first explanations that comes to mind for me beyond the sovereignty and fear of losing business points that Juliette raised is also just the sheer challenge involved in having 15 judges reach agreement on issues like this, especially when these are people that typically, and I'm speaking generally here, lack experience in domestic litigation. So for the most part, these judges are not coming from a background where they've been litigators at the domestic level. And I think if that were true, I think we would see a different approach to evidence, because you would have common law and civil law lawyers coming to the bench with substantial experience in how evidentiary problems are dealt with in their domestic systems. And I think that there might actually be more convergence than we might realize between, for instance, civil and common law jurisdictions there. But that's, for the most part, really not the background of these individuals. And they also, for the most part, haven't been domestic judges. So to my mind, it also has to do a lot with the credentials, the experience, life and professional experiences of these people. And then I'd also like to pick up on the issue of questions from the bench, because this also, of course, very much relates to whether the judges are being reactive and passive or more proactive in character. And, I think the Myanmar case is a good example of where the judges were more actively involved at the end of the first round of oral hearings. They asked a lot of questions, more than normal. And a lot of the questions concerned evidence. So there, I think we see that that's a sure sign that the judges are really actively engaging, at least behind the scenes, with the evidentiary problems that this case raises.
Yeah, and I remember reading a chapter written by Ken Keith about the reference to the aerial herbicide Columbia case, and I think there was something like 30,000 pages of annexes and evidence in that case. And he said, the court read all of it. There was this real endeavor to engage with the facts, as overwhelming as that might sort of seem. But your point about the background training is a really interesting one, and one I hadn't really sat down to think about previously. I mean, maybe we can come back to this at the end if we talk about potential avenues forward or solutions. But I mean, would a little bit of judicial training maybe be in order for people who've been career diplomats up until this point? But I just want to move on because both of you mentioned a key case, and it's the case which piqued my interest in this topic, the Gambia and Myanmar. Not very many weeks ago, we had the merits hearings in that case. They went on for an extended period of time across three weeks, was it, I think? And there's been several interesting evidence issues arise in the course of that case. And two that stand out for me are the court's reliance on fact-finding reports issued by UN agencies, the fact-finding mission on Myanmar established by the UN Human Rights Council, to be very precise. And then separately, the use of in-person witnesses and confidential in-person witnesses as well. We saw a closed court for several of these sessions. So I'm interested to know what each of you think about either of these practices or both.
Yeah, I mean, maybe I can kick us off on this. I mean, Gambia, Myanmar, I think is a really fascinating case from a fact-finding point of view. And I think also potentially a really significant case as well in light of the cases that are also on the court's docket at the moment, particularly other genocide cases. How you prove allegations of genocide, I think, is something that the court is now having to address without the benefit of facts having been tested before criminal tribunals before. So in Bosnian genocide and Croatian genocide, the court in a way had the benefit, if you can call it that, of relying on facts that had been tested through a adversarial process, applying a sort of criminal law standard of proof. Now, we're in sort of uncharted territory in that sense, and in these cases where the court doesn't have that benefit, and it will not have that benefit, one would imagine, in future cases either. So what the court does in Gambia and Myanmar, I think, is very much going to set the stage for other cases that are pending before the court. And we can maybe pick out, it's kind of hard to narrow down, I think, the number of important fact-finding issues from Gambia and Myanmar. When I sat down to watch and read the oral proceedings, normally you can just pick out the fact-finding bits and skip over the rest. I basically would have been as well highlighting the entire 3 weeks of proceedings. It was really so much focused on evidence and fact-finding. But if we were to pick out some which I think are particularly important, I mean, of course, we have to talk about fact-finding inquiries. We can also talk about witnesses, and maybe we can start there and say something briefly on this, because it's hard to say too much, because Juliette, as you said, this took place in camera. We don't know exactly how the witnesses were questioned. We get, interestingly, some snippets or some insight into the types of questions that were asked in the second round of proceedings, where counsel actually refer back to some of the questions that were asked of the witnesses. So, for example, we know from the second round that Judge Nalta asked one of the witnesses about why one of the victims felt that they were being attacked, and whether the other members of the Rohingya group felt that they were being targeted. Was this because did they feel that they were subject to an attempt at genocide, or was it merely to get them to leave the territory? We don't know much more than that, because we don't have access really to what was asked there. So what we can say is limited. I mean, the number of experts put forward was smaller than in previous cases, than in Southwest Africa. the Bosnian genocide, for example, we only have three witnesses put forward by the Gambia and one by Myanmar. So it didn't take up too much of the court's time. But as to the evidentiary value of what the witnesses added, I think we don't know. I'm not sure if Cecily wants to add anything specifically on that point.
Yeah, I agree with what you said. There's not very many witnesses, right? So there were three witnesses called by the Gambia and one by Myanmar. And it's clear enough to me, I guess, that the witnesses called by the Gambia are basically comparable to those that were called by Croatia in the Croatia-Serbia case, insofar as they are people who appear, based on what I can glean from the second round of the proceedings, they were people who survived attacks and could describe what they saw, which is basically what you have also in the Croatia case. But as you've indicated, this is not very many witnesses. So the Gambia called just three, and we don't know why they only called three. So we don't have the kind of contextual information that you might like to have about why these three were selected. So this suggests to me that these what they contribute then to the evidentiary record will be limited, just partly by virtue of just the limited number, and also because we don't know what they said, which also limits, I think, the extent to which the court will be able to reference, although that remains to be seen. And I would also note that it was different in the Croatia case because I went back and looked at those transcripts. Those were not closed sessions.
Yeah,
And
they
actually,
were
Keir
they were
Starmer was doing the questioning,
yeah.
which I had forgotten. But
They
there you
hid the
go.
names of the witnesses, didn't they? But it
Yeah,
was
so
yeah.
it's easier to understand in that case. Also, I think, limited contribution that they made. And there, of course, the court was able to rely on the jurisprudence or to reference the jurisprudence of the ICTY. So that was just a different case. But I think the fact that these sessions were closed is very understandable, given that the security situation in Myanmar is quite different from what it was in Croatia at the time of the oral proceedings in that case. And I can fully imagine that these witnesses would be under threat if their identities were known. And of course, that makes the proceedings then at the ICJ more comparable to what you would see at a criminal court, which I
Yeah.
think seems appropriate.
Yeah. And it's interesting, isn't it, that I mean, there's maybe two other issues here. One is the importance, I think, from a victim advocacy point of view of having people who have been subjected to this be able to tell their story in court. But then in some might say because it's not going on the public record, the value of that storytelling is potentially diminished a little bit. It's present at an individual level, but not maybe in a historical record kind of a way. And then I guess the other question is perhaps, as you say, there was only three witnesses, and how much can that limited number of people speak to the experience of an entire group? Is maybe and that might be a challenge for the court in how much weight they give this evidence or what they do with this evidence.
Yeah, I'd actually like to follow up there and talk briefly about the witness statements that were put forward by the Gambia. So related but separate as an
Mm.
evidentiary issue. So the Gambia put forward a number of witness statements which are anonymous. And, counsel for Myanmar was very thorough in pointing out all of the evidentiary problems that it could find with the evidence relied on by the Gambia. And this was one of the critiques raised then by counsel for Myanmar. And here, going back to the point about the court perhaps being overly reactive or passive, I would have thought that the court could have resolved that by requesting to see those not anonymized witness statements basically in camera without Myanmar being given access to those signed witness statements. So to my mind, that would have been a perfectly valid option available to the court to resolve what I indeed see as an evidentiary problem. I think it's problematic for the court to be given anonymized witness statements, not knowing who they are.
Yeah, indeed. I quite agree. And maybe this leads in a way to the next thing which stood out, which was this reliance on these UN fact-finding reports, because, in a situation where it is extremely difficult to get eyewitness accounts, are these UN agencies playing a stand-in kind of a role as the fact finders? But is that itself problematic? Because then is the court abrogating its responsibility as the primary fact finder over to these other agencies who maybe have even fewer safeguards when it comes to how they collect these facts? I'm not like impugning their integrity or anything, but we don't know what methodology they're using or anything, really. It's kind of, however you can go about it. So what do we think?
Well, so the
Well,
fact-finding mission in its reports explains its methodology. So there is written information available about how they went about things. And they're following official UN guidance on how to collect facts. So they definitely have a methodology. They're pretty transparent about it. And yet, I think that I think unfortunately, Myanmar's council did raise valid questions about the methods employed by the fact-finding mission. And in the second round of the proceedings, I think that counsel for the Gambia went a long way towards addressing, at the very least addressing, I'm not sure totally putting to rest, but addressing those critiques. And one of the critiques concerns reliance on witnesses who may be repeating hearsay rather than what they've witnessed themselves. And there were concerns about, the interview notes that there was one set of interview notes that was made available, which was not very helpful for the Gambia's case. And those were also addressed in the second round. But I think the upshot is that there are, unfortunately, quite a few questions about how the fact finders went about their work. And this idea is not original to me. It's from Mike Becker, but the fact finders, the three members of the mission, or maybe people who worked for them, could have been called by the court to testify, to explain how they went about things, how they gathered evidence. That would have also been a valid path forward for the court, I think. But in
yeah, I mean,
general,
I
I
think it's
think
maybe
sorry,
worth
go ahead,
taking
Julie.
a step back and reminding ourselves why UN fact-finding missions are particularly important here, right? Because I mean, you have an applicant in this case in the Gambia, which is geographically removed, and you have challenges in the applicant gathering evidence to substantiate its claims, and it bears the burden of proof. And the standard of proof in genocide cases, as we know, is higher than in other cases, right? In accordance with the gravity of the crime. And the complicating factor here is that, of course, Myanmar didn't allow the fact-finding missions access to its territory, right? This is something that Judge Gomez Robledo asked specifically, what are the legal consequences? Is there any sort of legal duty of cooperation that we can draw from the UN Charter, for example, to allow fact-finding missions to enter your territory? Alina Miron for Myanmar simply said no. There's no legal obligation whatsoever in relation to that. So you have essentially these fact-finding missions, which, as Cecily says, I mean, we do know a bit about their methodology. We know a bit about the identity of the people involved as well. But they're over the border in this Cox's Bazar in Bangladesh, and they're speaking to the Rohingya there. And this presents real fact-finding challenges, right? Because you have apparently the presence of ARSA, of the armed group, in the camps, and so there's questions that Myanmar raises about whether these people were freely giving their accounts to the fact finders or not. But I think it's safe to say, I mean, counsel for Myanmar said that the UN fact-finding reports are the evidential centerpiece of the case. And I think that that's absolutely true, and it may well be the case in other pending cases. So what the court does, how much probative value it accords to the findings of these fact-finding reports, despite the sort of evidentiary flaws, some of which Cecily mentioned, and I agree are genuinely problematic. I think will have a really significant bearing on future cases. And maybe just to add one more thing as well, Cecily mentioned about Mick Becker's idea about calling the drafters of the fact-finding reports to testify before the court. There was an affidavit submitted by Assistant Secretary General to the court of the other body, the subsequent one, the Independent Investigative Mechanism for Myanmar, about the work that had been performed. And he had actually indicated he would be willing to come to The Hague and speak. But it's noted in the oral proceedings that he was blocked from doing so by the Office of Legal Affairs of the UN in New York. So that does raise a question about why did that arise and would it in the future?
Yeah, that's
Yeah,
very
I want to jump in
interesting.
there.
Yeah.
Yeah, so the Gambia included him on their witness list. And then the OLA in New York said no, he shouldn't testify to avoid doubt about his impartiality. But for me, the question this raises, but what if the court had asked for him to come, right? So then there's not a question of him testifying on behalf of Gambia. He would then be a court-appointed witness or expert. So
Yes,
I think
exactly.
that option was available to the court here, but they didn't take it, and we don't know why exactly, but we do know that they are in general comfortable relying on fact-finding reports produced by UN bodies.
Hmm.
So the court has in the past been willing to do that. Most recently, of course, in the DRC
Sorry, can I
Uganda,
interrupt? This is
Spaniard.
an absolute nightmare scenario, but the fire alarm has just gone off.
Oh no.
So,
This is not our first tech problem we've had on the pod. It is not insurmountable. Ladies and gentlemen,
okay, so do
we
you
will join
mind
with
if we
you. One
pause?
moment, one moment. Apologies, dear listeners. We had a fire alarm go off and one of our guests had to depart, but everyone is safe and sound, so we can carry on. Now, we were just talking about the court's reliance in the Gambia case on these fact-finding reports issued by UN agencies and the prospect of maybe calling as witnesses, calling the court, that is, calling as witnesses, the authors of some of these reports. James, did you have any thoughts on this as a potential practice?
Yeah, I think Cecily is right in what she said that there may have been a different reaction from the Office of Legal Affairs had the court specifically requested that he appear as a witness. And that may be what has to happen in the future, because, as I said, this will be an issue in pending cases. And the relationship between the court and other UN bodies, I think, is a really super interesting one. And it's one that actually the Gambia tried to make something of in this case in particular. So Philippe Sands, for example, described the court, or he made a big thing about the court being the UN's principal judicial organ. And in his words, I think he said that the court was at the end of a pipeline, which, goes from the 1948 Convention through the General Assembly and the Human Rights Council, which establishes these fact-finding bodies. And there was a real appeal to the sort of UN nature of these fact-finding bodies as being disinterested witnesses, and that would mean that the facts gathered by those fact-finding missions were particularly authoritative. It's an argument that's been made before, but I think not in such explicit terms, in an attempt to really tie the court to its UN function and to try to convince the court that things that are contained in UN reports are things that it should give particular credence to. And maybe just from an intervention point of view, it's worth noting that the Gambia made a big thing of the joint intervention under Article 63 of the UK, Germany, and Canada, and so on, who've made a similar point about the value of UN fact-finding missions in particular.
Yeah, it's interesting this emphasis on the court as being part of this institutional architecture that is producing these reports. And so I suppose the point being made is it's less an abrogation of the court's fact-finding responsibility as it is an outsourcing or a delegation of that to another arm of the United Nations. I have just one more question about the. Oh, Cecily, go on.
Yeah, I just want to briefly mention that I do think it's really regrettable that the court couldn't rely on anything from the ICC here.
Mm.
So I teach the decision to authorize the investigation into the the Myanmar Bangladesh situation to my bachelor students. And it's from 2019 and it's now 2026. And on their website, I can only see that they've issued one application for an arrest warrant. And maybe the rest is confidential, but in any event, this is really slow. And there's language on the website about reinvigorating the investigations, which suggests to me that it was maybe not so active for a period of time. But it is conceivable that there could have been a judgment from the ICC in this time. I don't think that that's expecting necessarily too much. And I just want to emphasize that point because we haven't touched on it. And it's disappointing to me that that it looks like not very much has been done, at least from an outsider's perspective at the ICC.
Yeah, it's not normally the ICJ who's the front runner on getting judgments issued in these. So I think that's a really good point. And as you mentioned, the other genocide cases had the benefit of other proceedings that they could refer to and rely on that did have stringent evidence requirements because they were criminal proceedings. I think this is just my one last question on this topic because obviously I am known online as the procedure goblin and procedure is always forefront of my mind. And what I'm interested in is this idea of you've both mentioned the importance of this case for future genocide cases, and we all know which one we're thinking of, and that's the Gaza case. We have seen the court rely on similar UN type reports in the provisional measures stages, and it makes sense in those because, of course, it's quick. You've got to get the facts you can get. It makes perfect logical sense. But to what extent do you think this practice of relying on UN fact-finding reports, let's assume the reports are found to be of good quality and they're relied on to establish the facts in this case, does that establish a certain kind of procedural precedent when it comes to proving evidence at the court that we now expect the court to rely on these? Or would it really depend on the nature of the fact-finding investigation or what they were able to do? Like, would there be reasons to not take this approach in other cases?
But in my opinion, the court's jurisprudence on this point is underdeveloped. So it's not as if they've said nothing on the topic, but what they've said is brief and sometimes not entirely coherent if you line the cases up. So if you go back to the merits judgment in DRC Uganda, what the court said there about when it will rely on a fact-finding report is hard to fully reconcile with the approach that is taken in other cases. So in that merits judgment, it said, for instance, that the method used by the fact finders had to resemble a court-like process involving, for instance, the cross-examination of witnesses, which fact-finding bodies don't do. So at least not for the most part. That's not a standard technique used by a UN fact-finding mission. So I think it's hard to reconcile that statement and that judgment with what you can reasonably expect from a normal fact-finding body. But then if we fast forward to 2022, in the reparations judgment in that same case, you see there that the court indeed ended up relying quite heavily on reports produced by various UN bodies, including the Office of the High Commissioner for Human Rights. And of course, the important thing there is that the standard of proof was lower.
Mm.
So for the reparations phase of that case, the court was not applying beyond a reasonable doubt or other comparable standard, which is what the court is expected to do here. So that to me is one of the key issues, and it also came up in the questioning by the judges.
Yeah, I mean it's going to be interesting to see. I think there's a real tension here between the idea that facts should be gathered by a third party or that the court should somehow step in and use its powers to clarify certain things or to even engage in its own fact finding. And the idea that in contentious cases, we're dealing with an adversarial process in which the applicant bears the burden of proof and must meet the standard of proof. And if they don't, then their claims can't be considered to have been established. And I think given that the court is operating under time constraints, budget constraints, every time it wants to appoint one of its experts, it needs to go to the General Assembly and ask for more money. I think there are certain factors which just mean that it simply has to be that it's on the applicant to ensure that they discharge the duty that they have to try to meet the standard of proof in these cases. And it can't be that it is for the court or even for UN fact-finding bodies, as much as they have, I think, professionalized and are really, really mindful of gathering evidence. I mean, this is explicitly the mandate of the independent investigative mechanism for Myanmar, to gather facts with future court proceedings in mind. Still, I don't think that that's ever going to really replace the role of the applicant in doing its own fact finding and trying to win its own case.
Cecily?
No, I agree. I think we should leave it at that. I totally agree.
We love some good solid agreement on the podcast. Okay, so I'm going to leave the Gambia case there. I mean, we could probably talk about it all night, but there was another evidentiary issue which came up in recent jurisprudence, and again, this might be an ICJ quirk, and it's the use of phantom experts. This came up in the climate change advisory opinion proceedings when the court issued a press release stating that it had met with scientific experts behind closed doors. Now, Cecily, you have written with friend of the pod, Mike Becker, about this very topic. Could you explain to our listeners, I mean, what the heck is a phantom expert and whether there are any problems with this?
Yeah. Yeah. So the word phantom expert, to put it in more mundane terms, it's someone who's hired by the registry of the court on a temporary basis to support the court, to support the judges with technical aspects of whatever case they're working on at that moment. So typically then we're talking about hydrographers, cartographers, people who can mainly help the court with land and maritime boundary cases. So that's my understanding of the usual context in which the court has historically followed its practice of using what we're calling a phantom expert, a ghost expert. And the interesting thing, and I teach my master's students about this, is that this practice was not well understood from the outside until judges Al-Kasane and Sima, in their joint dissenting opinion in the Pulp Mills case, which is definitely worth a read, critiqued this practice. And in doing so, if you look carefully at the way it's constructed, they've actually cited passages by Jennings and the then registrar of the court as sort of to make it clear that they're not the first ones to speak publicly about this, that other people from the court had previously mentioned this. So they're basically, but they drew a lot of attention then at that moment in 2010 to this practice, which is problematic procedurally. And it runs, I think, very clearly against the good administration of justice, because it means that the parties, first of all, have no voice in establishing or even awareness of the manner in which the experts are used by the court. And they have no opportunity then to review the court's choice of the experts and to comment upon what they'll be doing. And they have no opportunity to comment on what the findings are of the experts. So then, I worked at the court a couple of years after the Pulp Mills judgment. And it was clear at that moment in time that the Pulp Mills case and the dissenting opinion that I just mentioned were still sort of reverberating within the court, that the judges were indeed actively thinking about how they should improve their practice and go about dealing with experts in a procedurally more proper manner. And so then in the maritime limitation case between Costa Rica and Nicaragua a few years later, the court did indeed appoint experts, when I think maybe if they hadn't had the Pulp Mills experience, they just would have relied on internal consultants. And then, of course, more recently in the DRC Uganda reparations phase, they also appointed experts, but that went less well, I think, to use a broad brush. So there, the court appointed experts to help it quantify the heads of damage there. And what the experts produced was ultimately not very helpful to the court.
Yeah,
So
James?
what we see,
Oh,
in
sorry.
other words, to sort of sum up here, is that the court, in general, at least I was under the impression that they've indeed moved away from the practice of ghost experts, phantom experts. But then in the climate change advisory opinion, they they did meet behind closed doors with experts. They didn't give the participants in the proceedings the opportunity to comment on the selection or to review what was discussed. There could have been a transcript of the questions and the answers, but there wasn't. And I think from a procedural perspective, that's not desirable. But also, that was a complicated case because there were so many participants. So it wouldn't have, I think, been productive or manageable for the court to solicit opinions from all of the participants on its consultations with those experts from the IPCC.
Yeah, I mean, I have to say, I would be a bit more relaxed about this recent example, and it's also my understanding that this practice has come to an end. May be mistaken, and I think if the court is thinking about going back to regularly using phantom experts, then that would not be good. But things are different in advisory proceedings. You know, the issues with using phantom experts, as Cecily said, relate to due process and the rights of the parties, and we just don't have parties in advisory proceedings. So if the court is telling us that it's consulting experts in a proceedings which are about, you know, complicated stuff with a lot of climate science, I mean, to me, that's a good thing. And I would say it doesn't raise the same type of due process concerns that would be raised had they been contentious proceedings.
Mm. Yeah, that's a very good point. I've also heard it said that, these were, again, sort of falling within the UN framework, these scientists supposedly UN, as part of that overall UNFCCC framework. And so that it was more appropriate for the court to meet with these persons, even if they weren't known on an individual level. It was funny that they issued a press release about it. It's not quite a phantom expert. It's sort of like somewhere in between. Like it's not a ghost. It's a zombie or something. It's like half and half, half alive, half dead.
Yeah.
But yeah, so we've seen, okay, so to sort of sum up, we've seen that the court has definitely made some strides in its approach to evidence, and that there are lots of complications, but that there aren't, at the end of the day, there's still no rules, right? It's not like a domestic court where you've got very strict rules of evidence about what can and cannot be admitted and the kinds of weight that you give to things. So do you both think that we need more careful regulation of evidence before either the ICJ in particular, has been our major topic of conversation, or international courts and tribunals more generally? And if so, how would you see that happening? Is it forum-based rule reform? Is there a possibility of some kind of separate treaty about evidence that applies across jurisdictions where states agree to take certain approaches to fact finding in their cases? Is more judicial training an option, and who would be doing that? What do we think? Blue sky thinking.
Well, I mean, it's hard to talk about one size fits all solutions here. And maybe in the interest of trying to be a bit more precise, I would just focus my comments on the ICJ, also because it's the court I know best. I, I think the way that the court is doing it sort of is working, right? I mean, there are skeletal provisions on evidence in the statute, but in the rules there are more, and the court can always amend its rules, and in fact has been regularly amending its rules. We see that in relation to other things like intervention recently, for example, and reporting obligations on provisional measures. And I don't see why the court couldn't do that if it felt the need to in the future. But because of the sort of skeletal provisions in the statute, the court has been building up its own procedure, taking as its starting point the very first contentious case in Corfu Channel and sort of building on that and refining it. And I think it is sort of moving in the right direction. And if you were to listen to Philippe Sands in Gambia, Myanmar, he would say that the court, in fact, has a well-established procedural approach. And I think there's an element of truth in that. We know the broad outlines of, for example, how cross-examination is going to be conducted has changed recently, right? I mean, we don't see examination in chief so much anymore. We see like experts being invited to like attest to a written statement, and then we move directly to the cross-examination. But the court is, I think, mindful of these procedural issues. It builds on its previous jurisprudence, and it's sort of moving incrementally with the times, I would say. So I would be against the sort of more radical solution, I think, and maybe be more on board with the more pragmatic approach that the court's been taking in the last decade or so.
Yeah, the idea that they're progressively building on their jurisprudence, which does bit by bit clarify what they're doing and what they expect. And I agree that I don't think rules, practice directions that apply to a number of international courts and tribunals would really be a workable solution. But I do think that if the ICJ were to move first, that other institutions would pay attention and potentially follow. Because when you do, and Juliette, you would probably know more about this than I do, but when you do a comparative analysis of the rules of international courts and tribunals, what you often see, not across the board, but often, is that the ICJ's rules have been essentially copied on a whole range of procedural questions. But I would like to put an idea forward about practice directions. So if you look on the court's website, the last practice direction that they issued was in 2009, which is a really long time ago. And one thing that's always struck me as odd about the Pulp Mills case is where they say in one of the paragraphs that they would prefer to have experts appointed by a party appear as experts and not as counsel, for, again, reasons of the good administration of justice. And I've always found it strange that that was done in a paragraph in a judgment rather than in a practice direction. It strikes me as something that would be perfect for that purpose. And I don't know, I can't tell you why they've stopped essentially using practice directions as a way to guide the parties on a range of procedural issues, including evidence.
Yeah, I think that's actually a really pragmatic solution. It takes what James has said about the progressive development through jurisprudence, but it offers clearer guidance to parties before the court, which I think it would be timely actually, because the court is extremely busy and we're seeing plenty of states appearing or getting involved in cases that haven't been involved in cases before. And, even though often the lawyers involved in these cases have some experience, I think the more that the court can offer by way of guidance about expectations for parties, the better. Well, look, thank you both so much. And I think in the interest of time, it's probably about time we wrapped up. But when we do wrap up, we always ask first-time guests our three famous questions, and they're usually the most dreaded questions. So, first up, what recommendations do you have for anyone who would like to know more about what we've discussed today? We can put any recommendations that you may have in the show notes. Second, what are you working on at the moment? And third, and importantly in these trying times, what is your current escape route? What are you doing, reading, or viewing that takes your mind off international law? James, would you like to start us off?
Yeah, and I'm going to be a bit of a suck up because one of the two things, which I think the two pieces that are the best things written on fact finding in recent years is written by Cecily. This is her piece on the armed activities reparations phase in the JIDs from 2025. And the other piece that I would recommend is a piece by Mike Becker on fact finding reports and their interaction with the ICJ. I think it's a really helpful piece that gives an overview of recent practice, and I think will be much read in light of upcoming cases. What am I working on at the moment? Well, I should be working on my own research. Most recently, I've been working mainly on being one of the three coaches of the University of Glasgow Jessup team. So maybe after the international rounds in DC, I'll get back to writing something with a former colleague from Berlin, Malcolm Jorgensen, on US interpretations of the rule of law and US foreign policy. So
how topical.
That's maybe fun. Yeah. And
And
finally,
so,
escape route. I
yeah,
mean,
escape route.
my usual escape route is my beloved Glasgow Celtic Football Club. Unfortunately, that is causing me more anxiety than the state of the world at the moment, given that we're locked in a three-way race for the title. But maybe I could recommend a monograph that I was gifted recently, which I've been really enjoying by Athenian artist Stelios Paidakis, and it's called Hell on Earth. It's about, yeah, a street artist who takes inspiration from religious iconic art and applies it to contemporary themes like workers' rights and the disintegration of society. So I thought that was quite topical just now. So
Indeed.
I would recommend this art and this book, Hell on Earth, to anyone who's interested in his art, particularly because it reminds me aesthetically of my favorite artist, the Scottish writer and painter Alistair Gray.
Beautiful. We'll definitely add those recommendations to the show notes. Cecily.
Well, so I was actually planning on recommending the piece that James published in ELGIL in 2023 on fact-finding before the International Court of Justice, which is a great and insightful piece, I think. So that would be at the top of my list. In terms of what I'm working on at the moment, well, I should be working on a book that I'm writing with Mike Becker and Massimo Lando on international dispute settlement. But actually, what I have to work on is advice that I'm writing on behalf of the Dutch advisory body on, and I can say this publicly because it's all on the website, compensation, in particular, lump sum compensation, in particular with respect to the downing of MH17. So that's been pretty research intensive and interesting, but also challenging. And as for life and distractions, well, my two kids who are 7 and 9 definitely take my mind off of international law. And also, speaking of sports, the boot camp group that I'm a part of that meets in the park nearby. That helps a lot.
Boot camp. That's intense. That's good. Cecily Rose, formidable woman, both physically and mentally. All right. Well, look, thank you both ever so much. I have had a wonderful time talking all things evidence with you both. I think it's probably timely to wish all Jessup contenders best of luck for the international rounds. I know I've had a few chats with various teams over recent days and weeks. And good luck to the Celtics as well. I don't know anything about football, but I hope your team wins. Sports. All right. Thank you so much. And farewell, listeners. We will see you next time. Bye bye.